Okay, abusia ba makwa aba sonko so ene ba POG Media so abusia yembonra eye yensem no breaking news bi abai no ene ya project ato ye screen no enchen de amamono petitions for removal of Chief Justice. The Supreme Court has by a 4-1 majority decision dismissed 2 injunctions applications seeking to restrain the Committee of Inquiry probing petitions to remove Chief Justice Torkonoo. Abusia Supreme Court NPP amanyukuku bi enkofo bi a echese omo file application to what Supreme Court say enka omonya den enka omombo Chief Justice Torkonoo yi ni no suspension omombo entunguna we NHS court tenase masa wabu abu ankofo no wa dismisses our 2 injunctions in abusia enye asem keto Akroma me enko ne enkonko tie ensema lawyer Martin Pegu eka efa medamase.
The processes have led to a committee being set up, and now we know that the work of this committee has started in earnest, amongst many other things. Let's take the latest we're learning to private legal practitioner Martin Pegu on this argument being put before the court, where they say the processes leading to the suspension of the Chief Justice is questionable. Counsel, let me take your thoughts on the legal processes or the legal hurdles that this constitutional process has had to face over the last 2 or so months. What do you make of it? People really testing the law and seeking to have muddy waters made clear, or you find these as deliberate attempts to obstruct the ongoing process?
Well, Martin, I think let's put it this way. They can be an amalgam of all what you stated and even more. Yes, so it can be a very complex combination of everything you stated and even beyond that. Because naturally, well, okay, even the word is not naturally, it often happens that when a case is in court, sometimes when you delay it helps. You delay it so that some winds can also blow across, and then the case can suffer some good times, right? And so even if somebody is guilty or liable, depending on the times, the seasons, the person can get away, etc., right? So sometimes lawyers file these things to delay and hope that the case will suffer some good fortune, all right? In the same manner too, sometimes lawyers file cases to test the law. Yes, because they want to improve the law, right, etc., and many more. So we cannot rule out any of the reasons you've given. That's how to analyze this. In a society, that's the way it is. You won't have all of us having the same kind of mind. No, people have different minds, different levels of deviance, etc. So these things play out. And just like the way we say, if you be a mensa womb, right. In every profession, yes, you'll find mensa, etc. So everything applies, everything you've said.
But considering that we've seen some rulings on a number of some of the concerns raised in the past, there were questions as to whether or not the petition should have been handed over to the CJ in earnest. Some have raised other concerns as to the constitution of the committee and the likes. It does appear the Supreme Court has settled some bits and pieces of this. Now we're learning of an attempt to injunct the process altogether. What do you make of it? The case that we're in uncharted waters, and hence people are really seeking to get an understanding of the entire process.
Okay, as I stated earlier, sometimes people want to engage the law. They want to try different things. So, and we cannot take that away from them. Every citizen is allowed. Okay, sovereignty resides in the people. That's Article 1 of the Constitution, all right, and also preamble and other parts of the Constitution, right? Article 125, etc. So when people want to exercise that power, right, and also justice also emanates from the people. So a citizen can look at something and think that, no, this is not just. So I want to approach the highest court of the land. We should grant the citizen that, yes. So at least the citizen will have the opportunity to ventilate his case in court. By he's not guaranteed a win. But even if it's not guaranteed a win, at least it's a form of expression. So he will be happy at the end of the process that, well, we took the matter to court and the court also gave him an opinion. So for me, that's how we should look at it. Yes, because it's impossible to say everybody should shut up and just let the process go on unimpeded.
All right. Counsel, there's another leg of the argument I want to invite you to, having to do with details of the committee's work expected to be in camera, which we're learning about. We've got, to an extent, who is representing who in terms of the petitioners and the likes. There are those who make the argument that that could be infringing upon the framers of the Constitution and that specific provisions, intended purpose, that all of this should be held in camera. Where do you stand on that argument that, well, it serves the interests of the entire public if some bits and pieces can be known during this entire process?
Good. Yeah, so where I stand is that the Constitution is obviously behind the citizens. That the citizens' quest for transparency has moved far ahead of the Constitution. And we should note that in most Supreme Court decisions, the Supreme Court repeats the values of our Constitution, the spirit, or if you don't hear value, you see them say the spirit of the Constitution. The Supreme Court has drummed time with our number that the values or the spirit of the Constitution, all right, are transparency, probity, accountability, right, etc. So you see that citizens are asking for transparency, and also it's a form of accountability. What is the accountability? Yes, when the citizens hear and see how the questions are being asked and answered, it's also accountability. So accountability doesn't mean the person should be found liable, pay this, pay X, pay Y, or be sent to jail. No, that's not the only form of accountability. When you are put on the stand, the witness enters the box and is answering questions. That's a form of accountability. When the Chief Justice is making her case through the witnesses, right, asking questions to show that this is my case, it's a form of accountability. So the point is that the citizens want to see more of the action because they want more accountability. They want to see what went wrong. So I'm in favor of parts of the case being made public. So you can see that the citizens have moved ahead of the Constitution, way ahead of the Constitution. So we'll have to look at it. It's obvious that in the new Constitution, parts of the process will have to be made public, minimum. But ideally, the whole process will have to be made public. And it's good even the chairman of the Constitution Review Committee, Professor Akuffo, he's already made his opinion known that he thinks parts of it should be made public. And so we are in good hands. I believe at least his stance will also influence the final document. So all the citizens who are asking to see what is going on, please remember to send memos to the Constitution Review Committee. Send memos. You don't need a lawyer. Just write. You just take pen and paper, write your address. So and so. I feel that in the new Constitution, Article 146 should not, even if you don't say Article 146, just write simple English. When it comes to the removal of the Chief Justice, we want to see everything. Or if it's not everything, the part you want to see, just write it like that. Take it there. Send the email. They will accept it. You don't need a lawyer. You can write ordinary English. That's it. Yes.
Right, Counsel, appreciate that you could speak to us this afternoon. We're getting to know as well of the reason why this latest group is in court. They want the entire process injuncted because the prima facie determination was not made available to the Chief Justice, which has informed the Constitution of this committee. I just want to take your opinions briefly on the arguments they are making. Then I connect with my colleague Lord Eduasare as well, who's in court. That's the argument they are making, that the prima facie determination by the Council of State and the President was not made available to the Chief Justice before the next step, which is the committee and its hearing now.
Okay, on the face of it, I see. Okay, so they're saying they didn't get, the Chief Justice didn't get a copy. But how did they know? That's the first question we should be finding out. It shouldn't that be a matter for the Chief Justice to take up? Who gave them that information? On what basis are they proceeding? Because the thing is supposed to be secretive, right? The Chief Justice has lawyers. So are we saying that if the Chief Justice didn't get a copy, her lawyers cannot write to the committee, or the lawyers cannot file such an application? Yes, you know, in this whole process, the proxies and the other, call them proxies, proxies also, people who have been filing things on this and purporting to fight a case, they seem to be making matters complex, to say the least. The Chief Justice has a lawyer, minimum, or lawyers. So how? The lawyer can't file on behalf of the Chief Justice?
Right,
because
Counsel.
there's something to be said. If it comes to the substance of giving the Chief Justice a copy, I'm strongly in favor of it.
Right.
But what is curious is how it is not coming from the Chief Justice,
but from private individuals.
Yes.
Thank you very much, Counsel. I appreciate, as always, you speaking to us. Let's go right now to Lord Edwasari, who's my colleague in court for us, because we understand two separate applications are before the court. The first is the injunction, which we've just mentioned, where they are making the argument that the prima facie determination was not made available to the Chief Justice, hence the ongoing committee work be injuncted. Lord, you have the rest of the details as well in relation to the other application before the court. Walk us through them briefly.
Right, Marina. So the case being heard before the Apex Court right now has to do with the CSO. They are the Center for Citizenship, Constitutional and Electoral Systems. Now, in their case, they have the Attorney General, the Chief Justice, the suspended Chief Justice, I should say, Torkonoo, and then Justice Gabriel Kwamang as the defendants in the case. Now, their matter is that the Chief Justice should have been afforded as a where the prima facie determination to respond to. As part of the exhibit that they attached to their documents, they indicated that they have evidence, and they cited some of the documents that Marina, you've seen in circulation on social media as part of the thing that, although the case or the matter before the committee should be in camera, it's in the public domain. So they're actually asking the court to injunct the processes, injunct the committee, and then also suspend the suspension warrants of the Chief Justice, which was issued by President Mahama. Now, they cite Justice Kwamang because he's the chairperson of the committee, and then for some reason the Chief Justice herself has been named as a defendant. Now, her lawyer, who was also in court, lawyer Addo, his case was slightly different. Now, he argues that there wasn't any prima facie determination at all. He indicates that if there was, it should have been made available to the Chief Justice, or it should have even been mentioned in the first place, because as it stands, there were 3 petitions that we know were forwarded to the President, which he subsequently sent to the Council of State, at which point the prima facie was determined. Now, he indicates that per the law, they should have indicated which of the petitions in which that prima facie was determined, which allegations they found the prima facie. All this was not stated, except that there was a communication by the Secretary of the President indicating that the prima facie had been determined, and so the Chief Justice had been subsequently suspended. And so these matters are still being argued in court. Before stepping out, the Deputy Attorney General, who is leading the prosecution as the defense, was also making this case that it should be struck out because the documents that they have attached to their affidavits are documents that should be classified, essentially, at which point the lawyer indicated that they are in the public domain. They found that on social media. And then the panel of justices, this time was Amadou Tanko, he questioned him that, is he sure, can he verify that these documents that he says he acquired from social media are the classified documents that were afforded to the Council of State members, or the committee, I should say. And that argument is still ongoing as we speak. So, Mana, once we have more, we'll get back to you on that.
Most definitely, Lord. Thank you very much for those details. That's my colleague, Lord Iduasare, with details of the ongoing hearing in the court for us. And most definitely, we'll return to him as and when there is more. But let's bring you some other stories this afternoon.
Now, the Commission on Human Rights and Administrative Justice is raising human rights and dignity concerns over the recent operation by the Ghana Immigration Service in picking up undocumented foreigners currently in the country. The Ghana Immigration Service last week picked up over 2,000 of these undocumented foreigners from major intersections following growing concerns of them constituting a nuisance on the country's roads. But that the means of ridding them off the streets is coming under some scrutiny by human rights groups. Shraj, who wants the Ghana Immigration Service to handle the undocumented foreigners with care. Well, let's show you a bit more of what we are learning from that statement released by Shraj. Now, remember, over 2,000 of these foreigners were picked up last week in response to the Ghana Immigration Service exercise. Now, government's decision to send back undocumented migrants where necessary should be done in a humane and dignified manner. That's the major call that it's being made on the Ghana Immigration Service. They also go on to say in that statement that in the considered view of the Commission, Ghana avoid situations whereby migrants sent back to their countries of origin may face persecution or harm, thereby violating the principle of non-refoulement under international law. Well, now, so that's coming from Shraj, which is calling on the Ghana Immigration Service to do this the right way. Let's have a conversation with Paul Nana Kwabena Abrompa Mensa, Programs Manager in charge of Security Sector Governance at the Ghana Center for Democratic Development and a member of the Coalition of CSOs on Migration. Paul, good afternoon to you, and thank you so much for joining us here on the news. But Paul, do tell us, from your analysis of this exercise, what exactly has the Ghana Immigration Service done wrong?
Well, good afternoon, and let me say a very good afternoon to also our listeners. And let me also acknowledge the support the German Development Corporation, GIG, the Migration Department has been giving the coalition on migration. It's just a mere coincidence that our communique that we issued last 2 weeks and also repeated this week coincided with the exercise of the GIS, and therefore it fits well with the discussions that we are offering this afternoon. It's two ways. One, let us acknowledge the fact that Ghana has signed on to regional, sub-regional commitments on safe, orderly, and regular migration. What it means is that Ghana is going to ensure that it does not treat migrants any way they like, and they are going to conform to international principles in the handling of migration issues. So I believe it's on basis of that Third Right International and Shraj are giving a caution that Ghana takes care and also remembers the commitments that it has signed to in handling the issues of migrants. But let's also acknowledge that there are two issues in swooping of irregular migrants in the country. One, because voluntarily the migrants are out of lack of capacity, especially the minors, not being able to go to the migration department to regularize their stay or lodge their complaint of those who are going out of forced migration. Forced migration is where they are being persecuted in their countries, there are insecurity in their country, and therefore they are seeking shelter in other countries. So this exercise afford those people the opportunity to lay their problems to the migration department to either listen to them, regularize them, or see to their concerns. On the other hand, people have also entered the country that on the point of entry, the migration agencies could not profile them. And therefore, they do this exercise from time to time to be able to update their records and know who is staying in the country irregular or legally. So it's a two-way sword that I think in both sides need to be handled and handled well.
Indeed. So, I mean, where do we then draw the line? Because it would appear this is a very thin line between Ghana.
Okay, abusuya we ne ensema ekoso ewo political highway. So lawyer Martin Pebu and I say ode sa ensem no to na beda ma sesa mo je pene kokoti sa audio no e de mi aha POG Media so beda ma say